In 2023, the Supreme Court killed affirmative action in their ruling Students for Fair Admission versus Harvard. There was another joined case where UNC, the oldest public institution, as Harvard is the oldest private higher education institution, was a named defendant. My guest, Justin Driver, a professor at Yale Law School, assesses the state of affirmative action now and also looks back as to the logic of the case and the ruling. His new book is called The Fall of Affirmative Action, Race, the Supreme Court, and the Future of Higher Education. Hello, Justin. Welcome to The Gist.
Thanks so much for having me. Glad to be with you.
So at the risk of stepping on my own show's name, give me the gist of just what you thought the legal missteps were that the conservative justices fell into in your opinion, deciding this case the wrong way.
Yeah, so the Supreme Court, in an opinion by Chief Justice Roberts, invalidated affirmative action. From a precedent standpoint, the Supreme Court had repeatedly upheld affirmative action across decades dating back to the 1970s. And so they deviated from precedent, including in trying to say that they were honoring precedent in the Grutter versus Bollinger decision, which was written in 2003. My old boss, Justice O'Connor, wrote the opinion for the court there and included a sunset provision saying we fully expect that 25 years hence, affirmative action will no longer be necessary. Rather than saying we overrule this decision, the court with some creative math said, oh, we're actually honoring the 2028 sunset because the class of students that are going to be admitted in the next round will graduate in 2028, but that can't...
So you think they were playing a little bit of linguistic games with that?
That can't be the right analysis. The 2028 deadline must matter for the government making decisions or other educational institutions making decisions rather than the date of graduation. After all, yes, college takes 4 years, although many people take longer. Law schools typically take 3 years for the degree to run its course. Business schools typically would take 2 years. So by this logic, law schools should have been able to use affirmative action for another year. Business schools should have been able to use it for another 2 years. And that's surely not what they had in mind. So,
but I do want to get to the sunset provision, but even go beyond what that the conservative justices were arguing had changed. Are you saying hadn't really changed in terms of the law?
Yeah. So they believe that colorblindness is often the order of the day. Chief Justice Roberts says eliminating racial discrimination means eliminating all of it. Of course, even within the context of the opinion itself, it then goes on to say, well, students can write essays that talk about their struggles with sort of racial discrimination and their abilities to overcome things. The court also gave a reprieve from complying with the opinion to the military academies. And the truth is, nobody believes in constitutional colorblindness. My biggest beef with the decision is that I feared that the decision would lead to a decline in Black enrollment in elite colleges and universities. I believe that affirmative action made tremendous improvements to American society, and that what happens on college campuses doesn't stay there, and it's going to have ramifications throughout American society. And I'm sorry to say that the nation has witnessed plummeting Black enrollment rates at many of our fine universities. MIT went from 15% Black to 5% Black. Amherst went from 11% Black to 3% Black. Princeton just reported its most recent numbers. It's down to 5% Black. So this is going to have catastrophic, cascading consequences for American society.
Definitely want to talk about that and the stats. But here's what I want to hone in on with the sunset provision and the fact of violating decades of precedent, the concept of stare decisis. If there is a sunset idea, was your justice not saying this is the sort of case where stare decisis need not apply? Or is your contention more she was making a prediction about where society would go? She wasn't making a normative statement about this current court, or not this current court, but the Supreme Court may in a couple of decades be justified in not adhering to the logic we're advancing now in 2003.
The 2003 decision and the sunset provision, highly unusual from a standpoint of constitutional law. Some people would say, well, we should just regard that as dicta, meaning not a binding part of the court's holding. It was sort of a musing, if you will. Mm-hmm. But others would say, and I would put myself in this camp, that precisely because it was so unusual and so specific, that we should treat it as a part of the holding. Indeed, Justice Clarence Thomas in dissent referred to the 25-year sunset provision as a holding. Justice Kennedy referred to it as a pronouncement. My difficulty is that the court says, oh, yes, we're honoring this 2028 provision, when I don't think that math quite adds up.
Yeah, I get that, but I guess in more terms of something a little more than common sense, or I don't want to just fall back on the notion of common sense, because that could mean whatever you want it to mean. But here we have a justice who is voting to affirm affirmative action, saying, but this doesn't necessarily mean there should always be affirmative action. This doesn't necessarily mean the thing we're saying today will be said in the future. And that contradicts the idea of once a court says it, it's got to always say it, which is the stare decisis idea. So no matter what Thomas or the conservative said, and it does seem, I'll say again, common sense, maybe there's a better phrase, plain reading, that this, if there was ever a kind of body of ruling that could be reversed, the court was signaling this is it.
It's a very interesting point, the idea that the sunset provision put the precedent on shaky ground and sort of undermine the concept. I think that what you're gesturing toward, and this is quite perceptive, is that there was a deep ambivalence about affirmative action at the Supreme Court in 2003 with the Grutter decision. But that ambivalence might also be found in Justice Powell's initial opinion in the Bakke decision from 1978, where he says, you can't have affirmative action for sort of racial remediation. Instead, diversity is the order of the day. And the ambivalence was found in subsequent opinions involving the University of Texas, where they say you really have to make extra sure that you're not using affirmative action more than is necessary. So I disagree respectfully with the court and its ambivalence. As I suggested, I think that affirmative action really did make a tremendous positive transformation of American society. Let me just give you a couple of quick statistics. In the fall of 1960, Harvard, Yale, and Princeton had a grand total out of 3,000 students entering, 15 of them were Black. That is 1/2 of 1%. You flash forward a decade, and it's just shy of 300 Black students who are entering these storied institutions. And I regard it as a challenge to the racial dynamics that have defined American society for too long. Those folks that are part of that cohort went on to become engineers and physicians and lawyers, not podcasters just yet, but they really did change the.
Thank God for them.
They really did change
better ground beneath their feet. Yeah,
they really did change the face of professional American society, and that had incredible tangible effects and symbolic effects for the place of Black people in American society.
Right. So I, as someone who doesn't know as much, nearly as much as you do about the court's decision and how they got there, but I think I do know a lot about the policies in society. I would say the problem with that, it is true, and you quote Orlando Patterson, who I've always liked because he was a great proponent and describer of the Black middle class. I would say for decades and decades, affirmative action was necessary. If I was on the court in 2003, probably would have voted for it. And you can't run the experiment again. it does become a question. But in 2015, in 2019, in 2023, is this thing that we needed in 1960, before the Civil Rights Act, is this thing that we needed still needed and still allowable under the law as we know it? And that is where I think some of the arguments, maybe they were clever, but I also think they were compelling, especially as regards Asian students, were to be taken seriously. So what would you say to that?
This question of timing has haunted affirmative action at the Supreme Court from its very first days. When the court entertained the Bakke case in the 1970s, the conference, the collection of justices, started banding around, well, how long is this really going to be necessary for? There were some justices who said that universities may use affirmative action in some contexts, who said, well, we think this is going to be good for 10 years, was what one person said. Justice Thurgood Marshall, who ran the NAACP Legal Defense and Education Fund and, of course, argued Brown versus Board of Education, said that he thought it would be required for a century. And some of his colleagues thought that that was sort of unimaginable. So there has been an ongoing debate about the timing of this. And of course, these considerations have not completely disappeared from American society in the aftermath of SFFA. And one of the things I'm trying to do in the book, as you know, is to identify the path going forward. And of course, I am not in any way interested in defiance of the Supreme Court's decision. There are some people who have openly said, oh, universities should just flout the Supreme Court's decision and do whatever it takes.
Yeah.
I don't believe...
If they're clever, they couch it in different language. But yeah, that's essentially what they're saying.
I don't believe in defiance. I think that the rule of law is a really fragile thing. And that fragility has never been clearer to us than in this moment than you and I are speaking in right now. I do also believe, though, that universities do not have to be in any sense underhanded as they pursue racial diversity. Indeed, the Trump administration has been brandishing a warped understanding of exactly what SFFA means. And they believe, the Trump administration does, that it sweeps much more broadly than it actually sweeps.
Right. So I would say the Trump administration stipulated they go way too far. That doesn't mean the Supreme Court did, though. Of course, I know that you say they did. Let's get into the specific cases where the plaintiffs in these cases didn't just sue based on white people being excluded. That was the characteristic of past cases. They looked at Asian students. There's a lot in the book about this. But I was looking at in fact, I didn't have to look at it anew. I have done things on the show about what is the actual effect. And you wrote a recent op-ed in the New York Times about this, the actual effect of this ruling. And yeah, there are many statistics that you can draw from individual colleges where, and you said a couple here on the show, Black enrollment went down. Do we as a society... should we celebrate or even be okay with the fact that there used to be 11% of students at MIT, the top, maybe with CIT, the top technical school, and now it's 3 who are Black? That's not a good thing. But overall, and I'm not accusing you of cherry picking, because you're right directionally, and your very op-ed in the New York Times links to this excellent statistical analysis. And they said overall, from what they could see, Black enrollment at these elite schools, or Black and Hispanic, went down by 1%, and white enrollment went up by maybe 1%. But from different schools, it's often wildly disparate. And what has happened in so many of the schools is that Black enrollment does go down, and the beneficiaries are not white students. You mentioned Amherst. Their white enrollment, which was hasn't been above 50% for 10 years, white enrollment didn't go up. Asian enrollment went up, or Asian American enrollment, since they count, Chinese nationals and Asians differently. Or if you look at one of the other great technical schools in America, I have this right here. Hold on one second. Yeah. let's look at the Carnegie Mellon, since we're talking school by school, what happened pre and post this decision. They were at, in 2021, 39% Asian enrollment was Carnegie Mellon. Now it's at 49%. And white enrollment went from 28% to 26%. And I'm not cherry picking. This happened over and over again. So I'll stop talking. I'm not going to recite all 59 colleges. But hasn't this generally been the trend that it is Asians who have benefited from this ruling? Yes, at the expense of black students.
Yeah. One of the things I try to do in the book is take quite seriously the claims by Asian American students who oppose affirmative action. And I say that, their allegations really do sound in a register of subordination, and that the same stereotypes that were applied to Jewish students 100 years ago at Ivy League schools are being applied to Asian American students today with respect to them being, grinds, not well-rounded, right? These sorts of odious stereotypes.
And even, they might have great test scores, but their personalities, very subjective, aren't up to snuff. Yeah.
Exactly. So I really try to emphasize these claims, and this is the right way to understand what their legal position is. I will say with respect to Asian American students, one of the fascinating phenomena to have arisen after the court's decision has been the rise of racial non-disclosure among applicants. One of the things that the decision has done is highlighted the notion that being Asian American on an application could lead to lowering one's opportunity to be admitted. And so more and more students overwhelmingly in the Asian American community are declining to check a race altogether. And that has caused universities to respond in a particular way, because some universities in the immediate aftermath of SFFA did not report sort of increased Asian American enrollment. In fact, they reported decreased Asian American enrollment. I don't think that was actually what was happening on the ground. I think that universities were reporting the racial percentages, as they always did, of the entire incoming class. And because more and more Asian American students were not ticking off the racial box at all, it suggested that there was a decline when there actually wasn't. Harvard reported its racial numbers relatively late in the day last year, and they changed how they were doing it. Rather than reporting race as a percentage of the entire class, they instead reported race as a percentage of those who did check a racial box altogether, and they did not find the decline.
Yeah, that's not a good faith way to do it, I wouldn't say. But to go back to
Mike, with respect, I don't think that what Harvard was doing was untoward. I think that given that this phenomenon was concentrated among particular applicants, that simply ignoring a decent percentage of the class, it was leading a misimpression, giving a misimpression that there were fewer Asian American students there than were actually there, and so they just decided. Okay. So I just would hate to leave it hanging there that I was saying Harvard had done something untoward. I don't believe that they did.
So no problem, and we'll probably just cut that part out. It was mostly based on my misunderstanding. So I will say, but what about my thesis on this, which I've talked about on the show? There are trade-offs, and it's not all some picture of progress. And you could point to these schools, elite schools, where there is a cratering of black enrollment, and that's bad, and that's a cost. But it does, in general, seem that the biggest beneficiary was not whites, but Asians. And then you could say a lot of things about that, and you do in the book. But do you agree that that, in general, is what the statistics seem to be showing?
Yes, and here's what I would say in response to that. One can simultaneously, I believe, support affirmative action for, say, Black, Brown, Native American students, and simultaneously agree that if there is any sort of discrimination against Asian Americans in the college application process, that discrimination should be rooted out. I don't think that those views are incompatible. And another way of putting the point, and I think this is consistent with what you're saying, if assuming arguendo, sorry for the lawyerese, assuming arguendo, that there was a cap on Asian American enrollment at these places, that was in effect artificially propping up white students, say supporters of affirmative action, and that should be taken away. And one would expect to see a rise in Asian American enrollment under that logic.
But if there was no cap, it could just be the case that there are a set number of slots. There's a good argument, by the way, about distance learning and why does Yale only have to have how many? It's a big law school, but how many do you admit each year?
About 200 students a year.
Right. That's small. Why not admit 600? But anyway, if there is a cap on the number of students and some consideration goes towards the racial background of the student, but not if you're Asian, then of the 100 students, let's get the numbers closer to correct, then of the 60 students who might be admitted to Yale Law School who are Asian, maybe it will only be 45 who are admitted now if there is a rule that we could take race into account, but not the race if you are Asian, or not positively if you are Asian. So it wouldn't be a hard cap. It would just be the other consideration would crowd out Asian American students. Yeah.
The point that you're making is completely consistent with one that Chief Justice Roberts makes, where he says admissions is a zero-sum game, right? When you are taking one person, that means you're not taking somebody else, and that there are trade-offs here. I would say that those who are often speak in this register are saying, we really need merit in college admissions, without banging their fist on the table about the scourge that is legacy admissions or preferences for donors. Or even, what are we doing with all of these athletic teams that?
And what kind of athletic teams? What crew and fencing? The
boutique sports really do serve to have a racial effect on campuses. That how many people are actually watching fencing matches? It's not clear that that's really a rallying point for most colleges.
I mean, Sabre, yes, Epee, no. Let's be real. And there's really good scholarship about how this really is a de facto, backdoor, and by design way to keep the number of white students at elite institutions high. Yeah. So when did this ruling was made in 2023, but I don't even know the answer to this. Did you not see the effect in your first year class at Yale Law School until this year?
The first class that was admitted post-SFFA started last year, so they are now second-year students.
And did you see a big difference? I mean, what are the stats for Yale Law School?
There were some differences in the composition of the class. Other law schools have suffered massive declines. I'll talk about my alma mater, Harvard Law School. Mm-hmm. That class of students who began at Harvard last year had 19 students out of a class of 550 students, about 3% of the class. That's the smallest number of Black students since the mid-1960s at a first-year class. And Harvard Law School has proudly graduated more Black lawyers than any law school in the country, other than Howard, including, of course, former President Obama, current Justice Jackson. And so this is, it's not uncommon at Harvard Law School to say have 70 students in a first-year class that you're taking contracts or torts altogether. And I've spoken to, my colleagues who teach there, and they say you'll have 2 Black students in a class of 70. So this is going to have real consequences at other places. And, other law schools have experienced different things, and different colleges, as you were saying at the beginning of our conversation, have had differing experiences. And I suppose that shouldn't be terribly surprising, because these educational institutions are operating in silos because they fear sort of collusion would lead to antitrust. And so, different general counsels are going to have different interpretations of the decision. Admissions officers are going to be doing different things. So, and different schools are differently situated. So I don't think the fact that, there's been a range of enrollment rates, I don't think that's especially surprising.
Right. But it is not the case that the brilliant black potential law student who doesn't qualify or doesn't get admission to Harvard and would have under affirmative action, they're not excluded from the law. They maybe get into a school that's great, but not as great as Harvard, going by the rankings or something. I don't know, NYU. And then the NYU student who's black, who would have gotten into NYU if there was affirmative action, but isn't now, maybe they go to, I don't know, Notre Dame, to pick a school that gave us a Supreme Court justice too. Well, you tell me, in practical terms, that has you would say, giant effect on what, creating the next class of leaders or the income of blacks in general? Like, what's the effect of, what's the horror of that?
Sure. Law as a descriptive matter is an incredibly hierarchical profession. There are excellent law firms that stop recruiting at, the 5th or maybe the 8th best law school in the country. And people care where one goes to law school decades after you graduate. By the way, I am saying this as a descriptive matter, not as a normative matter. It's quite possible that it shouldn't be that way, but as a descriptive matter, the opportunities that are available to people at the very best law schools in the country are different in kind from the opportunities that are available, speaking broadly here, to people who are going to law schools in terms of these judicial clerkships and things of this nature. So there really is, a broad sort of effect here. And this is something that the Supreme Court in the Grutter decision mentioned, that a small number of schools play a disproportionate role in shaping who are our future leaders. One can say it shouldn't be that way, and I'd be inclined to agree with that. But from a descriptive standpoint, it is that way.
Well, I would think that may be true with law, more. With undergraduate, it definitely shouldn't be that way. And, I don't know what the lifelong benefits conferred on having graduated from UCLA instead of UC Riverside are, but they shouldn't be that great, and it shouldn't be. And I also think that can change. And let me posit this with the law. Maybe if Democrats in general have problems with these affirmative action rulings, they should look at this situation where we elevate certain law schools to an unreasonable level and say, you know what, for our next Supreme Court justices, we're not going to nominate only people who went to Harvard and Yale. Sorry to implicate your two institutions, but everyone on the Supreme Court, other than Amy Coney Barrett, went to Harvard and Yale. And then maybe the Republicans, who are always criticizing the Ivy Leagues, would do the same. It doesn't seem like a reality we're locked into, is what I'm saying.
It's very interesting. A lot of people have regretted that for a long time the ranks of the Supreme Court were drawn exclusively from lawyers who were educated at either Harvard or Yale. This has been something that people have spoken about with the Supreme Court dating back to the Nixon administration, where there was a nominee who I cannot name and probably should not name anyway, whose, record was not sort of overwhelmingly positive. And, people said the person was sort of a mediocrity. And there was an elected official who said, hey, the mediocre are allowed to a little representation too, So,
that's amazing.
Yeah.
It was Nebraska Republican Roman
Ruska, right?
Ruska.
Yeah.
Ruska, yes. Mediocrities need people too. Well, come on. You're not saying if you went to
No, of
NYU,
course not. Of course not.
No.
Of course not.
Oh,
that was a lighthearted
Gotcha.
sort of, moment there.
I want to get to two other things that you get to in the book. One is the idea of mismatch theory, and it's highly contested. But to summarize what it is, if we allow or if colleges and grad schools admit people who are not up to snuff or for whom the work will be challenging, we're not doing them a favor. And there is some highly contested scholarship that shows that there is at least something to this. Like if you look at and you deal with this, the bar rate passage of people who are admitted with lower LSAT scores, it's lower. It correlates, lower LSAT scores correlate to being unable to pass the bar on the first time or the second time. And then the same scholarship says, well, look at the difference between, and I chose these schools by design, UCLA and UC Riverside. Students who are admitted in a low 150-ish band of the LSATs do better on the bar, which is an objective criteria, if they went to UC Riverside than if they went to this quote unquote better law school. So the idea being a law school that meets the students where they are might be better for the students. What do you think of mismatch theory?
I want to emphasize where you began, which is that this is deeply contested work from an empirical standpoint. Richard Sander of UCLA Law School wrote a Stanford paper that got a tremendous amount of attention and received intensive pushback by PhDs with economics, including my colleague just down the hall here, Ian Ayres, and also at Stanford Law School. Professor Ho wrote an important article that really pushed back against this. So it's important to say that, but assuming the veracity of it, and this is one of the things that I try to take on in the book, I make a claim that even as assessed by conservative lights, mismatch is going to be intensified as a result of the SFFA decision rather than minimized by the SFFA opinion. And here I am trying to channel my inner conservative, such as it is. That's a hard thing for me to do.
Yeah. And we should tell listeners, the book starts off, it's like the first chapter is going to be, I'm going to pretend I'm a conservative who believes in this and give you the best arguments. So
yes, exactly,
that was a fair effort to that.
Exactly so. And so with respect to the mismatch portion of the argument, colleges and universities are going to continue to want to enroll Black students. It's going to be easier for them after SFFA to enroll the valedictorian or the salutatorian of an underperforming urban high school rather than the B plus A minus student from Andover. And it's quite possible, according to conservatives themselves, including Justice Thomas, that a student who attends an underachieving urban high school is going to have great difficulties adjusting from a social standpoint on elite college campuses in comparison to the A minus B plus student from Andover. And so if one is truly committed to minimizing mismatch, it seems to me that the old system, the pre-SFFA system, was better than the new system, in part because the claim might be educators know what they're doing here and who is going to be equipped to thrive in a challenging academic environment.
Okay, I want to get to the part of the book where you recommend ways forward. So one of the arguments you put forward is instead of having a racial component to admissions, you can have the descendants of slave component. So this would pretty much exclude all immigrants or children of immigrants from African countries. And then it wouldn't be racial and perhaps banned under this logic. Lay that out for us a little bit.
Sure. It's an argument that's opened counterintuitively by originalism as to why preferences for the descendants of slaves would pass constitutional muster. A majority of the current court marches behind the originalist banner, and that originalism means that the Constitution should be interpreted according to the original public meaning. Well, originalists are typically opposed to affirmative action, but what do they do with the Freedmen's Bureau? A measure that was adopted contemporaneously with the ratification of the 14th Amendment's Equal Protection Clause. And most people would say the Freedmen's Bureau was designed to help Black people make their way from slavery to citizenship. Justice Thomas says, actually, no. The Freedmen's Bureau was not about race. In fact, it was just about the status of having been an enslaved person. In an oral argument, Justice Kavanaugh said, but that means that being descended from an enslaved person would not also be a racial category. And exactly as you say, Mike, there are Black people in America today who would fall on either side of the descendants of slave line, where people who are relatively recent immigrants to the country would not be able to check that box, and others would be able to check it. And the Supreme Court, in Chief Justice Roberts' opinion, says that what's forbidden is race qua race, race for the sake of race. And this is not a line that would be drawn on race qua race. And there are other lines that other sorts of preferences that would be available for universities to use that would not violate Chief Justice Roberts' prohibition on race qua race.
Yeah. And another interesting idea that you have that other people have, and they just put faux. You talk about what if admissions were allowed to take into account low opportunity applicants, as you call it. I think that most people would just say, well, what about class as a criteria instead of race? Lay out why you just don't say what about class, and how would this work, and would it work? Do you think it would work better than race qua race as a criteria? Yes.
So for a long time, people have been saying we should use class, not race, that this would sort of lower the temperature. There are, poor people in Appalachia, just as there are poor people in Anacostia. And there should be an ability for people who grow up in challenging circumstances to be able to make it. It's an incredibly appealing argument along many dimensions. When these plans are operationalized, they, at least in a crude fashion, they don't tend to lead to a lot more Black people on campus. Indeed, Princeton just reported its data last week, and it said that it has more Pell Grant recipients, more people from modest backgrounds than ever on campus. And it also has fewer Black people on campus than in decades. And so those two things need not go together. And so I try to suggest that we should tweak this idea, drawing upon the work of Raj Chetty and John Friedman, two economists who have led a team creating what they call the Opportunity Atlas, and which pays attention to census-tracked data to understand the sort of challenges that various neighborhoods confront. And I say that we should draw 80% of low opportunity applicants from urban areas and 20% from rural areas. I didn't just pull those figures out of my hat. The census tells us that there are 80% of Americans live in urban areas and 20% live in rural areas. And I think that would help. And of course, yes, Black people are disproportionately poor, but Black people are a minority. And so there are more poor white people than there are poor Black people. So, I think that one wants to be careful about rushing headlong into class, not race, without some other criteria that would be at work here. And I would also make the claim that we should really focus on wealth, not income, that's where some of the real discrepancies come in, and some of the major discrepancies with respect to race and money.
Yeah. I mean, you could very hard to get at what a person's wealth is. And if you're an admission committee, if you're the IRS, you can't do it, right? If you're an admission committee, I don't know if you can. So the last thing I'll ask you about is you've had a while to think about this and process this and write the book. And I did read your recent essay, The Excruciating Question Confronting Black College Applicants. And it's about the regrettable need or requirement or de facto requirement that Black applicants essentially parade their trauma to get admitted to schools. Was this, this was, I think, a foreseeable consequence. Well, you tell me, a foreseeable consequence of the part of the Roberts decision that had this carve out for essays. And I think it wasn't meant with ill intent, but you're putting your finger and saying that it did have a pernicious effect, right?
Yes. The dynamic is that under the old application model, a black applicant like myself could check the black box and then write an essay about why I wanted to study the Odyssey or Proust or, the Washington Nationals, whatever the case may be. Under the new regime, because universities have walled themselves off from considering race as part of the application process itself, black applicants are strongly incentivized to write essays that sort of emphasize, racial discrimination, racial trauma, regrettable dimensions. And that is especially ironic because conservatives for a long time have said the problem with affirmative action is that it instills a sort of victimology mindset. And that's very difficult to make advancement in society when you've construed yourself as a victim.
This infuriates him. He's written whole books about this.
Yes, exactly so. But it seems to me that these essays are a lot more constitutive than simply checking a box, which happens at the doctor's office or even some DMVs, whereas a successful college essay requires, drafting and redrafting and polishing and refining. And it seems to me that that's going to instill it. You ask whether this is foreseeable or unforeseeable. Some colleagues of mine say maybe the Roberts Court was sort of twirling its collective mustache and that this was not a vice but a virtue of instilling this. I will not go that far. I do not go that far in the book. I think that one of the difficulties here is that conservatives have been railing against affirmative action for so long with sort of kitchen sink style argumentation that there wasn't enough thought that went into what is the new approach going to look like and what are the frailties of that approach and are they actually worse than affirmative action. And I want to say, I am a defender of affirmative action. It is not a first best plan. It is a second best plan at best. It has frailties, but it also has made tremendous improvements to American society.
Justin Driver is the author of The Fall of Affirmative Action, Race, the Supreme Court, and the Future of Higher Education. Thank you so much.
Thank you. I really enjoyed the conversation.